resident ID is 2020495446. In this slide, I will explain about land acquisition. Land acquisition is a legal process in which the government takes possession of land for public use and pay the owner with the amount of ringgit compensation. According to the Land Acquisition Act 1960, this act relates to the land acquisition, assessing compensation to account for such acquisition and other incidental matters. In addition, this act was passed by the Seri Paduka Baginda Yang di-Pertuan Agong with the help and consent of Dewan Negara and Dewan Rakyat. The authority has also passed it. The Land Acquisition Act 1960 is the legislation that controls property owners' rights in Malaysia. A government, a private owner, or maybe an individual or a company cannot simply buy the land. It is because the land is a form of matter and subject for the jurisdiction of the state in which it is located. There are many processes to do before getting the land. In land acquisition, the state authority can acquire land for any public purpose. Enquiry should be held in such manner and at such place or places as the land administrator may deem fit, and on inquiring into the respective interests of all persons claiming compensation or who in his opinion are entitled to compensation in respect of the scheduled land, and into the objection, if any, made by any interested person to the area of scheduled land. The land administrator may, in lieu of making a written award under Section 14, make an oral award either in the form of monetary offer of compensation or otherwise, to every such person entitled in his opinion thereto.
That is, principle the acquisition of the land is clear that is the for the purpose has declared or has ensured in the defendant procedure of the as it of the act is that has been set out in the framework of S3 Act. This situation has made it clear that his tourism industry, namely Langkawi, is legal has one of the public purpose to be it has the acquisition of the land. As such, the General Chamber was correct in the descendant to dismiss the application made by the plaintiff.
In fact, about this case, the second respondent wished to erect a hotel on the land and had applied to the land administrator for respondent for permission to acquire part of the appellant land to build a direct access road to the second respondent property. To attempt to buy part of the land were successful, and unbeknownst to the appellant, a third attempt was made by declaring this it necessary for public purpose under Section 3(1)(a) of the Land Acquisition Act 1916. The Act appellant was given Form E to attend the land inquiry by the first respondent 9 months after the declaration to acquire the land. Form D was gazetted but was never served on or informed to him. The first respondent proceeded to serve Form H, which was a dedication to dismiss the appellant request for the acquisition to be delayed or withdrawn, and to proceed with the acquisition by making an award. Next, the appeal is now again the preliminary objection raised in the High Court. It was further submit that the High Court judge had raised in law and in fact failed to consider that the failure of the first respondent to make and deliver the award in Form H within 2 years on the appellant after Form D was gazetted was inconsistent with S8(4) of the Act, and thereby render the Gazette procurement declaration lapse, case dependent and void.
We move to the procedure of court case Ahmad Saman vs Kerajaan Kedah 2003. The appellant skill counsel agree that if the declaration in this matter is to be considered under Section 3, it must fall under paragraph A of that section. However, she said that the tourist industry, as defined in the statement, could not be considered as a public purpose because it is unclear how the general public will gain from it. She explained that in order for a purchase to fall under paragraph A, it must be demonstrated that it is in the public interest or for the benefit of the public or a specific section of the public. In this case, she claimed that the acquisition did not meet the foregoing condition. Second, she argued that the declaration in this case is unclear because it does not specify the true purpose for which the land was obtained, and hence it is invalid. In support of her claim, she cited the Indian case Madhya Pradesh Housing Board versus Muhammad Shafi and other 2 CC 1992-1C8. It is submitted on behalf of the respondent that the purpose for which the land is being acquired is within the expression public purpose as provided in paragraph 8 of section 3. The land judge in his ground of judgment agreed with the submission of the respondent. Based on the above authorities and reasons, I see no reason to disagree with the land legal advisor's contention that the tourist industry is indeed a public purpose within the ambit of Section 3 of the Act. The fact is further enhanced by the amendment of Section 3 of the Act by Act 04. Therefore, the plaintiff contention that in tourist industry is not a public purpose under Section 3 must fail.
Under Section 3 of the Land Acquisition Act of 1916 referred to as the Act, the defendant had sought to purchase certain land in Langkawi that belonged to the plaintiff. According to Section 8 of the Act, land acquisition for tourist industry was declared as the acquisition goal. The plaintiff requests a determination that all action conducted in response to the Gazette notification which was published in Warta Kerajaan Kedah number 3 jilid 33 were illegal insofar as they concern the acquisition of the land. The complaint argued that the acquisition went beyond the parameters of Section 3 of the Act and constitute an abuse of statutory authority. To the Court of Appeal, the plaintiff thus appealed. The question was whether purchasing land for the tourism industry fell under the criteria of public purpose and stated in Section 3 of the Act.
Another case law is Pemungut Hasil Tanah, Daerah Barat, Daya, Pulau Pinang v. Gaik. The principle is the doctrine of favor of the internal relation which has been made by subscription and the injustice which has also been caused by the landowner by his delay in holding and investigation under Section 10 of the Act and the making of the word. Delay in conducting investigation which have resulted in the inallocation, competition and being given similar to above of power and have also renewed investigation as well as proceeding for subsequent acquisition null and will and automatically invalidate.
The fact of this case. On April 25, 1974, the Penang State Authority issued a declaration under Section 8 of the Land Acquisition Act 1916 for the acquisition of land for a public use. The state authority declared in another Gazette notification on December 20, 1979 that an area of the state land along with some other land was required for a public purpose. This land was the subject of an investigation and compensation was awarded. On November 5, 1918, the collector announced that he will conduct an investigation into the original plot of land. Despite the respondent's objection, the inquiry was held and adjudication was reached. The respondent sought an order of statutory to overturn the investigation and award.
The next court case is Pemungut Hasil Hutan Daerah Barat Daya Pulau Pinang versus Gaik. The doctrine of exhaustion is not applicable as both declarations were declared under Section 8 of the Land Acquisition Act 1960. The constitutionality of the Land Acquisition Act is not in issue in this case, and no challenge was made against the Act for not providing adequate compensation or in any way being contrary to Clause 2 of Article 13 of the Federal Constitution. The collector's failure to undertake an investigation under Section 10 of the Land Acquisition Act 1960, 7 years after the declaration of acquisition, resulting in inadequate compensation for the respondent, placed the inquiry and award outside the Act's jurisdiction and scope. The purchase was not done in conformity with the Act because of the protracted delay, which resulting in injustice to the landowner, and the Land Judicial Commissioner was correct in directing the issue of an order of constitutory to quash the acquisition proceedings. The decision was upheld by the Supreme Court. We think it is sufficient to decide this appeal on the basis of simpler question, namely whether or not the acquisition was done in accordance with the law in view of the long delay resulting in an injustice to the landowner, said Saleh Abbas CJ Malaya, as he was then in delivering the Supreme Court's judgment in the Land Acquisition Act. Only if it is not done in accordance with the Act can we conclude that the acquisition is illegal, as stipulated in Clause 1 of Article 13 of the Federal Constitution, which states that every deprivation of property must be done in accordance with the law in order to be legal. The conclusion is the appeal dismissed.
After an investigation, recompense was given for the lands. The collector announced on November 5, 1918 that he will be conducting an inquiry into the original parcel of land. The respondent filed a petition for a writ of certiorari to overturn the award and the investigation. The delay in having the investigation required by Section 10 of the Act and the issuing of the award unfairly treated the landowner, as well as the doctrine of the exhaustion of an earlier statement by a later one. 7 years after the declaration of acquisition, the collector delayed holding the inquiry required by Section 10 of the Land Acquisition Act of 1916. As a result, the respondent received insufficient compensation, which caused the inquiry and award to fall outside the ambit and jurisdiction of the Act.
Okay, the last one is case law, Kijal report and sendiri yang berhad with Pentadbir Tanah, Kemaman and Anor. Okay, the principle is the conservation of the root and the land of the first respondent is presently because it is one of the matter permitted under Section 3. Okay, it was further submission that the High Court had error in law and in fact failed to consider that the failure of the first respondent to make and deliver the award in from hash within 2 years and on the appeal of the four from D was given was incident which as 8.
The fact of this case. Appellant is the rightful owner of the property. The respondent, defendant in the lower court wished to purchase the land on the ground mentioned in a statement made under Section 8 of the Land Acquisition Act 1916. The important part of the declaration is to hereby declare that certain land and areas specified in the secret letter are required for the following purpose: land acquisition for tourism, industry in Teluk Burau, Bukit Padam, Maksirat, Enquiry District. Upon investigation, the land administrator made an award of Rm46,815 in favour of the appellant as compensation for the land. Appellant object to the occupation and the money was subsequently deposited in the court.
Kijal Resort Sendirian Berhad vs Pentadbir Tanah Kemaman is the last court case. The procedure began with the High Court did not err in the sustaining and the preliminary objection. The appellant grievance was not so much on the award itself but the acquisition. The objection by the appellant at all times was in respect of the acquisition of its land, not the quantum of award itself. Because it was a decision to acquire that was being challenged, the challenge was brought against the state authorities' decision under Section 8 of the Act. Because the Act authorized the state authority to deprive a person of their property without compensation, its term must be scrupulously followed. If a power is stated to be in the hands of the state authority, it cannot be used by anybody else. The state authority could not take action against another for exercising its authority. The land administrator is only required to intervene if the state authority decided to open an inquiry to hear the applicants for compensation for all interests in such land. An action against the decision of the state authority could not name the land administrator. That's mentioned in paragraph 11 and 12. The 2-year time frame applied to the making of the award in Form G under Section 14(1) and not the giving of the notice in Form H under Section 16 of the Act. Therefore, the first respondent had acted well within the 2-year time frame from the date of Form D in paragraph 18.
The Terengganu local government has decided to acquire a portion of the applicant's land, the said land, as well as a portion of the second respondent's lands for public use. Following that, the Kemaman Land Administration first respondent published a notice of proposed acquisition in Form D, and the first respondent issued a notice in Form E. The applicant received a notice of award and compensation in relation to the prescribed Form H issued by the first respondent. Applicant refused to accept the compensation amount awarded by the first respondent and declared his intention to contest the acquisition. The applicant has chosen not to file an appeal against the first respondent's awards under remedies provided by Section 38 of the Act. The second respondent raised a preliminary objection at the inter-party hearing of the substantive application. Based on the issue of when the 14th day specific in A53K KMT should be counted, the Court of Appeal ruled that the 14 days should begin with the publication of the local authorities' decision in the Gazette via Form D, rather than the service of Form H by the Land Administration. The applicant also claimed that because his complaint was against the first respondent decision, the proper party had been named in the application. The respondent also argued that the time frame for filing a judicial review application should begin from the date of publication of Form D in the Gazette, not the date of service of Form H on the appellant. A question, an investigation, a request of information, or the act of gathering information are all considered inquiries. A less popular variation of inquiry is inquiry, provided that the land administration may obtain a written opinion on the value of the ceded lands from a value prior to making an award under Section 14. The land administration shall also inquire into respective interests of all persons claiming compensation on all who is its opinion are entitled to compensation in respect of the ceded land, and into the objection, if any, made by any interested person to the area of any ceded land. The land administration may, for a sufficient cause to be recorded by him in writing, postpone any inquiry or adjourn hearing of an inquiry from time to time.